How's it going, everyone? Spectre here, another video. We're talking once again about Studio Wildcard and Ark. I know, I thought I was done with this entire thing as well, but, well, you kind of have to do a little bit of watching the games that you do play, and I do still play Ark, even if the servers I play on are, all intents and purposes, dead. So, a little backstory. Studio Wildcard began these 25-man Conquest servers, pretty much giving some new servers a chance and kind of trying to mess around with the PvP meta and the play style. And they seem to be doing okay. But over the past couple of weeks, there have been some claims of hacking, who's surprised, meshing, glitching, and the like. Now, of course, who's involved in this? T. You don't know who T is in Ark. They are arguably the tribe that is talked about the most. They are a group of Chinese players. I'm not going to mince words here. They are Chinese players. They play very underhandedly. They are known for meshing, but almost every mega tribe on official servers are known for meshing. They are known for aimbotting and streaming it. Now, there's been some talk that team members might have family that works for Snail Games, and there has been evidence of GMs coming to defend T during major raids against them. Most notably, and this is what we're talking about, or ties into rather what we're talking about, there were 2 raids against T on the Conquest servers. Both tribes ended up having bans issued. They were locked out of the Conquest servers. Because T is so well known and they are such a contentious topic and there are so many issues, of course the players took to Reddit, of course the players took to the website to talk about this issue. And Studio Wildcard's response was the following. They decided to update the Conquest servers. Jen writes, the Ark Conquest servers on PC are a special initiative by our partner, Snail Games. Remember that Snail Games actually owns Studio Wildcard. They bought them out after Jeremy Stiglitz cost the company $40 million because he couldn't abide by the 1-year non-compete clause that he negotiated with Trendy Entertainment shortly before being forced out. Anyways, Snail Games to shake up the current PvP meta and play style. Now that these Conquest servers are up and running, we will be handing control of these servers over to them. Effective immediately, the Conquest servers will be wholly operated by Snail Games, and any future changes will be made by them. As part of this handoff, their team will be completely responsible for enforcement of the Code of Conduct, including the management of a unique global ban list separate from the main official network. Enforcement for the Conquest servers will be driven through the Conquest Discord, and future updates and news will be found here. In addition, we will be adding 9 new servers to the Conquest cluster this week. These new servers will have transfers disabled for 2 weeks at increased rates 3 times during that time. After the 2-week introductory period, server transfers will be enabled and the rates will be reduced to match the rest of the cluster, which is 2 times. This is to help tribes build up quickly in order to be at a competitive level against other players on Conquest servers. We thank you for your patience during this transition period. Now, this doesn't come as a surprise, really. Studio Wildcard has had terrible customer service since they really started early access. Really, when the game was just leaving early access, the customer service tanked even further. Snail Games is not going to give you customer service. If it is true that T does have a pocket dev, that they do have employees of Snail Games in their pocket, it's not going to matter. And the global ban list being separate doesn't really matter if Snail Games at any point can say, hey, this global ban list is being added to yours. Snail Games can enforce that on Wildcard. Now, once again, T is not exactly known for playing fair or playing in a way that is consistent with having a fair play style. This is partially because of the Chinese mindset of win at any cost. And this is not a racist statement, it's a statement of fact. There is a very noticeable mindset when it comes to Chinese players with regards to how they interact with other players. And the win at any cost mindset is very prevalent in their culture. With this being said, remember, the last set of ban waves that happened on official servers ended up hitting quite a number of tribes other than T, many of whom had invaded T. Spartans, I believe, left partially because of T, of the preferential treatment they were getting. So now that Snail Games is going to be running these Conquest servers, I think they're going to die faster than official. Once again, if this is all true, but there is a lot of compelling evidence from GMs getting involved in the fights themselves to huge issues with the way that a lot of the servers are maintained. A lot of DDoS attacks happen during times when T cannot defend themselves, but they know they're being attacked. T was not added to the global, where the enforcement policy list or the second round until there was a lot of negative publicity shined on Studio Wildcard, both on Reddit as well as in third-party publications. So the Conquest servers being handed off to Snail Games, this is just them passing the buck, which we've come to expect. Remember, they're working on their Extinction DLC. They haven't been working on the base game, fixing the issues. They actually came out with a little snippet of why they can't fix anything, pretty much. And it comes down to nobody really knows what the hell they're doing. The Snail Games taking over the Conquest servers. You're not going to get a response if you have a customer service issue. If you get banned, you are probably going to be permanently banned, and there's nothing you can do about it. The second story we're going to talk about is the TheQuartering's lawsuit. There has been an update. I'm going to pull up it itself. Now, I have asked Jeremy himself why he's not updating anybody. The last update he did was on the 13th, I want to say. It was last Friday. And it was hey, there's not much to say. But he says that's an update. Is it really an update if you pretty much say there's no update? This cost me 20 cents to get off Pacer. I have the document that apparently Jeremy doesn't have. Well, he didn't have. I ended up sending it to him. This is in regards to his complaint. Now remember, he spent between $5,000 and $15,000 on his lawyer. And the lawyer apparently, which let me just say right now, Bill Richmond is very well respected within the contractual law. He's very well respected. He knows what he's doing, but this might be outside his purview. He's pretty much going in a personal injury. He's for all intents and purposes become a glorified ambulance chaser. If you want a little backstory on the lawsuit, there are a couple of videos out there. I'll link to mine down below. But this is in regards to his complaint. Plaintiff has filed a complaint in which it alleges that this court has diversity jurisdiction over this matter. The court notes the following issues with plaintiff's jurisdictional allegations regarding the parties in this action. I just want to say right now that I did espouse some of these concerns, that they didn't actually establish jurisdiction, that they did not establish properly that this was the proper venue for this lawsuit. The judge actually touches a bit on this, and she, I believe it's a woman, really quick. Jane Magna Stinson. She adds to it. First, plaintiff alleges the parties' residences. An allegation of residence is inadequate, and she cites McMahon v. Bunomatic Corporation. Residency and citizenship are not the same, and it is the latter that matters for purposes of diversity, citing Mayerson v. Harrah's East Chicago Casino. Second, plaintiff alleges defendant's residence upon information and belief. But jurisdictional allegations must be made on personal knowledge, not on information and belief, to invoke the subject matter jurisdiction of a federal court. Remember, and I said this during my stream when I was talking about the complaint, information and belief is legalese for saying we actually don't know. We're relying on secondhand knowledge, maybe witness statements or something like that. So In order to establish the jurisdictional allegations, you have to have personal knowledge that this is true. She cites America's Best Inns versus Best Inns of Abilene. And quoting, only a statement about jurisdiction made on personal knowledge has any value, and a statement made to the best of my knowledge and belief is insufficient to engage diversity jurisdiction because it says nothing about citizenship. She also cites Page v. Wright and quotes an allegation of a party's citizenship for diversity purposes that is made only upon information and belief is unsupported. In the forthcoming amended complaint, plaintiff must ensure that the appropriate jurisdictional allegations are made on personal knowledge. Another thing to keep in mind here is that residence is different than citizenship. Residence just means that you might live part-time in the state. For example, you might have a summer home on Cape Cod that you spend 6 months there, and then you might have a winter home in Arizona, you spend 6 months there. Those are technically two different residences. Citizenship is different. It's pretty much, for the purposes of legal issues and whatnot, your citizenship is determined by, say, who issues your driver's license or state ID, where you're registered to vote, where you're registered for jury duty, etc. Citizenship is important because if it was just based on residence, well, what happens if you have multiple places that you live at all through the year? Different states, it kind of hurts there. And more to the point, if it was based on residence, all Matt Lauder would have to do is live in Wisconsin for 1 day, and he actually takes the jurisdiction of the court away because he lived in Wisconsin. So that's why citizenship is actually talked about in the statute, not residence. Finally, plaintiff does not properly allege the amount in controversy. The amount in controversy must exceed $75,000 exclusive of interest and costs, and she cites 28 United States Code section 1332. The exclusive of interest and cost language must be included in the amount in controversy allegation. As I said previously, there's no way $75,000 worth of damage is going to be proven. It's just impossible for that to be proven. His subs haven't taken a hit. He actually gained quite a few subs. I would say a bump in subs because it was picked up by Daily Wire, maybe it was Daily Caller, as well as the Campus Reform. So he did get picked up by national news. He saw a significant jump in subscription numbers because of it. The court orders plaintiff to file an amended complaint on or before October 22nd, 2018, which is this coming Monday, which addresses the issues outlined in this order and properly alleges a basis for this court's diversity jurisdiction. Defendant need not answer or otherwise respond to the complaint at which this order is directed. Defendant is cautioned, however, that when he does respond to the amended complaint, and to the extent that he denies any of the plaintiff's jurisdictional allegations or state that he does not have sufficient information to respond to those allegations, the court will require the parties to conduct whatever investigation is necessary and file a joint jurisdictional statement confirming that all parties are in agreement with the underlying jurisdictional allegations before the litigation moves forward. And this was entered on the 9th of October, which was not last Tuesday, but the Tuesday before. Remember that that Monday, the 8th, was a federal holiday, Columbus Day. So he has until Monday, Bill Richmond has until Monday to file the complaint, the amended complaint, by close of business. If he doesn't, a couple of things could happen, mainly dismissal of the case. Now, there's two ways it can be dismissed. Dismissal with prejudice, which means he can't refile. And it's very difficult to appeal a decision when you mess up like this. Other is it's dismissed without prejudice, which means he can refile at a later date. My expectation, and right now Pacer's not showing any kind of entry to show that there has been an amended complaint. My expectation is that they will either file for a continuance or they will dismiss without prejudice. They will willingly dismiss without prejudice. And this will give them time to actually look into the information, because all their information was based on information and belief. That's my expectation. I could be wrong. But once again, the fact that Quartering is not talking about this really speaks to the character of what is going on. So those are the two stories I wanted to cover in this video. Feel free to comment below, engage in a little bit of criticism, a little bit of banter if you want to. That's absolutely fine. I encourage it. Well, next time, I am Spectre. I'm out.